9:17, and right now we are highlighting a Supreme Court case out of Colorado. Just yesterday, the justices released a decision that could have a long-term impact on the LGBTQ plus community and other people in protected classes. The justices ruled in favor of a Christian web designer who refuses to make wedding websites for gay couples.
So now let's get out to Denver 7's Brandon Richard with more on that case. Brandon.
Yeah, Katie and Jessica, in a 6-3 ruling, the U.S. Supreme Court said it's okay for certain businesses to refuse to provide some services to LGBTQ plus people. Now, this morning, some are praising this decision. Others, though, call it shameful and disgraceful. Now, this whole case stems from a Colorado graphic designer. Her name is Lori Smith. She filed a lawsuit arguing that designing a website for a same-sex wedding conflicted with her religious views. She said that a Colorado anti-discrimination law, state law, would force her to do so and would violate her freedom of speech. Well, the conservative majority on the U.S. Supreme Court agreed with Smith, recognizing that her designs are free speech. And they said that the First Amendment allows all persons to think and speak as they wish, not as the government demands. The court's liberal minority criticized the decision, saying the court was giving businesses the constitutional right to refuse service to members of a protected class. Some worry this decision could be used to allow businesses to discriminate against other groups, those in an interracial marriage, for instance. And this ruling is receiving mixed reaction.
This is a victory not just for me, but for all of us. Whether you share my beliefs or completely disagree with them, free speech is for everyone.
That means a business could refuse to serve an interracial couple, claiming that interracial marriage is wrong. It means a payroll company or a photographer could say, I don't want to do business with women-owned businesses because I don't believe women should be working outside the home.
Colorado Attorney General Phil Weiser, who you just heard from there, says this is not over. He says more lawsuits are likely to be filed so they can figure out just how far businesses can go in refusing to provide service to certain groups. We're live in Denver this morning. Brandon Richard, Denver 7.
Brandon, thank you. So I've been following this case for months now, exploring the potential long-term impact of a ruling that certain businesses can refuse to serve certain people. Well, now that the ruling is official, we're bringing in a constitutional law expert for more perspective. We have attorney Terrence Carroll, who is also the 55th Speaker of the Colorado House of Representatives, weighing in here with us today. Thank you for being here.
Oh, thanks for having me.
So let's first start talking about precedent. There are legal experts who say that the court's ruling is not in line with prior cases. So what was the rule of law before, and does the Supreme Court actually have to follow precedent?
Well, the prior rule of law was based on the Civil Rights Act of 1964, which basically said you can't discriminate in public accommodations. If you go into the public marketplace and you offer your goods, you can't discriminate. And that's been the bedrock rule for more than 50 years. The Supreme Court's now turned that on its head with the 303 creative rule decision. And technically speaking, the Supreme Court does not have to follow precedent, although they like to say that they do. And they go with this thing called stare decisis, that once it's been decided, they kind of stick with it unless there's something new that comes along that causes them to think, maybe we didn't quite get this right the first time. And they've done that throughout history, especially in the realm of civil rights.
Okay, thank you for that perspective. Now next, how are consumers impacted by this ruling, and are some consumers more impacted by it than others?
Consumers generally may not see, the consumers broadly may not see a big difference, but consumers who come from groups that have been traditionally discriminated against, blacks, browns, people of color, women, LGBTQ plus community may, and it'll make it harder for those consumers to enter into the stream of commerce, because now they have to think, is this person going to say that I don't have to serve you because it violates my religious rights or it violates my free speech? And prior to this, you could pretty much confidently say, if I go into store A, I'm going to get service. Or if I reach out to web designer B, they have to provide me service. Now that it makes it a lot more blurry, and it in the sense that we don't know. I mean, you can say you don't want someone simply because of the color of their skin, all you have to do is say, hey, but my right to free expression is violated if I do this. So it makes it a little bit more hairy of a marketplace.
Okay, and also you did make something very clear there that this goes also beyond the realm of LGBTQ rights, and also to other people who are traditionally discriminated against could also be impacted by this ruling.
Absolutely.
Okay, so now recent Supreme Court cases are altering the civil rights landscape in our country. What rights do you think could be under review in the coming years?
One of the things that we've seen, and especially in Justice Thomas's dissent on some key civil rights bills this year, he wants to go back and visit things like Obergefell and Loving, which all deal with things like same-sex marriage, interracial marriage, even the case out of Texas that had to do with who can you have sex with in terms of is it illegal? Can you make gay sex illegal?
Lawrence.
So, Lawrence, thank you, Lawrence. The Lawrence case out of Texas. So there's some in the court, and there's some super conservative activists who want to go back and revisit that whole line of cases. So we should be aware of that and keep it on the front burner, and not just assume everything's cool. It's not. There's a definite assault on some bedrock principles that in the last 50 years we've all come to say, okay, this is okay, we all agree with this. There's some retrenchment from that right now.
Well, thank you so much, Attorney Carroll, for this perspective. All sorts of people are ruling in on, are speaking out on this right now. Some reaction from Colorado lawmakers, including Governor Jared Polis, saying these rulings run counter to Colorado values, and we will continue to fight against bigotry and discrimination in all its ugly forms. And Republican Representative Lauren Boebert saying today is a huge victory for religious liberty. Glad to see the Supreme Court make the right call here. And Republican Representative Doug Lamborn saying today's Supreme Court ruling in favor of Colorado's 303 Creative and Lori Smith is a victory for free speech and religious liberties everywhere. Americans of all faiths deserve First Amendment protections as they seek to uphold their fundamental beliefs. Hashtag free speech for all. We are going to continue to follow this case and the impact of other Supreme Court cases on our state here in Colorado. We'll see you after the break.